Every great once in a while, the YouTube gods bestow upon us the gift of a single police interaction, so profoundly dumb, yet so rich with opportunities for constitutional analysis that it almost seems unfair. The cop you're about to see really puts the duh in FLORIDUH. Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. So I was scrolling the YouTubes yesterday and I saw this video pop up on BP Cast's channel. So shout out to him for breaking the story. But as I watched it, it got crazier and crazier, almost to the point that I couldn't even unravel what I was watching in one single setting. But the good news is that I've endured the pain for you so that you wouldn't have to, and I'm ready to break it all down into manageable parts. Now, before I go any further, I want to identify the officer in question, and I want to show you a news story featuring him so you can get a sense of who he is and what his background is. Here's the news story from the WMBB 13 news channel out of the Florida Panhandle. Let's check it out.
Last year, one Calhoun County sheriff deputy wrote more than 1,000 traffic citations. Deputy Lonnie Baker has been employed by the sheriff's office there for 3 years, but has a background with the Florida Highway Patrol. As News 13's Bailey Nichols tells us, Baker says he just wants to keep drivers safe.
Lonnie Baker is a man on a mission. The Calhoun County Sheriff's Deputy has spent the last 3 years stalking the roadways. And in that time, he has acquired a serious reputation.
Just trying to save lives and protect the people of Calhoun County.
In 2023, Baker gave out more than 1,000 tickets.
I've been in law enforcement 22 years, and I've never witnessed anybody write a citation as efficiently as Deputy Lonnie Baker.
Shortly after Baker's 21st birthday, he joined the Florida Highway Patrol.
I found out my thing was more on the road, and I love traffic.
Since 1985, Baker was a state trooper and kept vigilant on roads and highways for more than 30 years before becoming a school resource officer in 2020. During his time as an SRO, however, he realized he missed being out in the field and transitioned back to road work in 2022. While writing this many tickets may be controversial to some, Baker says his work makes a positive difference.
You know, just save a life. I mean, I don't care where you're from, I'm just trying to save a life.
Last maybe 24 months, 36 months at the most, we've had no less than 10 fatalities on State Road 20.
Sheriff Glenn Kimbrell says that his office has received many complaints about people speeding. He's just glad that Baker is almost always on the scene to catch them. Just last Monday, Baker caught 18 people going 20 and 30 miles over the speed limit in the span of 4 hours. Baker says he's not trying to hit a quota, just hoping he can slow people down and stop a tragedy.
I mean, it's not a number, just trying to keep the roads safe here in Calhoun County for the people can, you know, if I can save a life or injury, that's my job.
In Calhoun County, Bailey Nichols, News 13, Panhandle Strong.
Now, the source video comes to us from a YouTube user named Danielle Paramore. I have no idea what connection that person has to the people in the video, but thanks to her for putting it up and making it available for us to analyze. Let's check it out.
Wrong. Just replace the damn TCU
the transmission control module messed up. I just put a new one in it.
Right.
And just testing it out, and it's still messed up.
Okay, but you driving it on the side. It can't be on the road.
We just have to drive it. We literally just.
But it can't be on the road. You got insurance on it?
Oh no, it's not mine.
Huh?
It's not mine. It's a guy I'm working for.
Okay. You got a license? You drive it?
I do.
You drive it. Okay, but it can't be on the road.
Okay, well, you can pull it.
Huh?
Yeah, we go. I mean, we pull it back or whatever.
We tow it.
Yeah, we just trying to get see.
No, you're not going to tow it. I'm gonna tow it. No. Who's beer?
That's
you can't do that, man.
Yes, I can. I can take his ass to jail. What are you talking about? I can't do it.
That ain't my shit. Take my breath all day long.
What are you talking? What do you?
The vehicle is 5449.
What do you mean I can't do it? Take your hands out your pocket. Take your hands out your fucking pocket, okay? Come here. I'm telling you, put your hands on the car. Put your hands on. You know what?
Get your phone out.
Hey, record. Hey, put your hands on the car. I'm telling you, put your hands on the car.
Okay, I ain't got nothing. Chill.
Okay.
Just chill.
I'm just saying,
just chill. All I'm doing is working on my car.
Okay,
man.
put your hands on the hood of the car. I'm just making sure. I'm just saying.
Be advised that there is a relay notice.
Oh, wait.
Yeah, can we just
No. Stand right there. You
have to be. It ain't even mine.
No, you want to talk shit though.
No, I don't want to talk shit.
Yes, you do.
I'm bound down. It's all you. It's all you. That's all you. That's all you. We just working on it, man.
Hey, Calhoun.
I mean, that's all.
Hold it. Stand over here.
That's all.
Hey, come here. Stand right there. Stand right there. Stand right over there. $8 to $20. Can you be in route? My 10-20.
Yeah, well, I'm in route.
Who's trying to give somebody a hard time? I'm trying to give somebody a hard time. No, I'm not trying to give nobody a hard time. You can't have a legal vehicle on the roadway. Yeah, you can't. Whose car is it? Whose car is it? No, you get the video. You get the video. Everything you said, okay. You welcome to the video I got. It's all video. I mean, let's see if the tag comes back. Hey, step around here. Step around here. Step around here. I'm telling you, step around here and keep your hands out your pocket, okay?
I ain't got nothing on.
No, I don't. No.
So I don't consent to search procedure.
What? I'm not gonna say what? Okay, I'm gonna stand right here. I'll stand right here. I got another deputy to be in like 15 minutes, okay?
I'm not resisting.
I know you're not. Because
I'm complying.
Okay, all right. What's your name? You not gonna give it to me?
Am I being detained?
Yes, okay, you wanna be, I'll tow the car and I'll take you to jail for something. I'll find to take you to. What's your name?
Why am I going to jail?
I'll find
I haven't did anything.
You got a legal car here. Yes, you do.
I wasn't driving.
Huh?
So it's on.
Okay,
on the road.
Wait till he get here. You going to jail? Okay, I'll take you to jail. I'm gonna take you to jail. Okay, you wanna play hardball? Tonight you
I haven't did anything.
Okay.
I haven't did anything. So you're just making up something.
You can call it what you want to. You going to jail as soon as he gets here. Cause you wanna run that yapper.
I'll get my cover table.
Hey, wait, you got your phone? Hey, you got your phone with you?
Hey, no, don't. Look, I'm gonna put you in my car. You want to sit in my car? You want to sit in my car? So be quiet. I'm telling you to be quiet. I'm telling you to be quiet.
Is that lawful order?
Huh? Yes, that's lawful order.
I haven't did anything. I'm doing nothing nefarious.
Now let's see. You want to run that yapper now? Okay, you can run that yapper.
I mean, just because there's another deputy here.
Okay, that's okay.
I mean, I haven't did anything.
No. I asked you what your name was. You're not gonna give me your name.
I haven't did anything.
Okay, all right.
You suspect me of a crime?
Yes, I do.
Well, what?
I do.
What?
Stand right there. Keep it. Put your hands so I can see them. Okay.
My hands right here.
Okay. Put your hands on. Okay.
What do you suspect me of?
Hey, will you watch it? You know his name.
What crime do you suspect me of committing? I haven't did anything.
Okay. You won't give us your name? Okay, that's good.
I haven't did anything.
Okay. You just stand right there then. Okay.
So, who's tripping? Is the body camera on?
I'm towing the car. See, I'm towing the car. Got a tow truck on the way.
For what reason?
And guess what? There's no tag on it. There's no tag on it. Make no difference. It can't be on the road. It can't be on the roadway.
So we had to go get the battery. Get somebody jump us the fuck off. That's it.
We was in the process of towing it.
They got them beer in that damn thing. It's not even ours. You can test both our breath. Shit.
Okay, I'm just saying. Okay, I'm just saying. I get a tow truck. I'll tow it. Hey, Calhoun, send me the next rotation, 1070. Next rotation, tow truck. 10-4.
10-4, 1026.
It's no tag, it's not registered. Copy of Florida Copy of VIN number. VIN number.
26, you go ahead.
Tempo is 1637 4802 00453.
That came back to a 2008 white Cadillac registered to Margie. Florida. Detail expired 10/31/25. Registration canceled. Insurance information is not on file. 5449.
Here it is. Here's the tag. Ain't that something?
Hey, it's expired.
That's 12/25.
That's
the end of the month. Don't go to the end of the month.
Hey, it's expired. That ain't the tag for the. That's not the tag for the car.
Why it ain't?
I just ran it. That ain't the tag. Since you know,
what they say.
That ain't the tag. That ain't the tag for it. That's not the tag for it. I'm not arguing with you. I'm towing it. I'm towing it. Hey, what's that tag number assigned to it? What is it?
The tag number
is
201R Romeo Tango Mike.
Okay, 201.
Yes, sir.
Okay.
And registration's been canceled as well.
Okay. Yes, sir. The driver, the woman was driving. Where's it? The one that was driving it. Let's see. Yes, sir. You was driving it. What's your name?
Huh?
What's your name?
Robert Lett.
What's first name?
Robert.
Okay. Robert.
Well, I'm gonna need badge number.
Okay, you get my badge number. Yeah, I'm the black guy at the sheriff department. That'd be easy to get. Okay. All right. Go ahead. Robert what?
Lett.
Okay, now I don't care about your normal name. You can get my name. Everybody in Calhoun County. Okay, good then. All right then. Well, that don't faze me none. What's your middle name?
Middle name? What you need my middle name? It's Gillette. Last name's Gillette.
Spell it.
Goulet.
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 Let. Let. What's your middle name?
A W.
For what?
Lonnie, it's Wayne.
Oh, okay. That's what I don't know your middle name.
I understand that. You don't need all that to look it up.
Yes, I do. I'm asking your name. You the driver? I mean, what's your date of birth?
Nobody was driving. It was.
Look here. Am I talking to you? Am I talking to you?
It was.
Am I? Step up here. I'm not. Can I step up here? Step up here and talk to me. I
don't have to see separated from people. Just
okay.
I'm leaving a number.
De-escalate.
No. Guess what? The first name. I'm not talking to you.
De-escalate. Calm down.
Guess what? Can you? You don't know what that means. You don't know what that means. You don't know that. You don't. No, you don't.
Believe it.
No. What's your date of birth? Okay, that's it.
Thank you, sir.
All right, that's it. $8 to $20. You can 1066. You can cancel. I've got 10 here. Yeah, we good though. I was gonna have you to walk the dog. I mean, we good though. They're just running their mouth stuff, but we good though. We good. Okay, but thank you though. Hey Siri, call dispatch. Hey Siri, call dispatch. Hey Siri, call dispatch. Hey Siri, call dispatch. Hey, what would you say that tag number was again? What's that tag number again? One more time.
The tag number again?
I lost it.
All right, hold on real quick. 201.
201.
Romeo Tango Mike.
RT 201. 201. It didn't even save it. 201 RTM. Okay, 201.
Expired vehicle registration.
No, I got a what you call? I got a
white Cadillac utility.
I got another one for. I got a guy's name. Run it for me.
Guy's name?
Robert Wayne Goulet. Robert Wayne Goulet.
You know his birthday?
Huh? Birthday 9/25/93. Photos, let's see, camera, let's see what I got. Registration, what's the registration at? I took a picture of it. What's the registration? Camera. Huh?
What you need?
Oh, nothing, you got his name and everything?
Yeah.
Okay, text it to me, his 20-something information, his address and all, text it to me. Okay, thank you, bye. Bye.
Are we still being detained?
No, y'all can go. I'm towing the car. Y'all can go. Bye. Y'all can go.
Well, hook the strap up.
Hook the strap up to what? No, not the car. The car being towed.
Let me get your badge over there. Lonnie?
What?
Let me get your badge number, partner.
Oh, well, we don't have a badge number.
You don't got badge number.
Yeah, look at my look at that. Do you see? That's my badge. You see a number on that?
Y'all got to have some kind of tradition.
No, we don't. Come on. You know my name. You know my name. I ain't trying to. We don't. Ain't no. You know my name. That's all you need. That's all. We don't have no badge number. Hey, guy. Hey, you ain't got to talk to him. It's not his car.
I can talk to anybody.
No, you can't. Hey, tow it. No, it ain't. No, he's towing the car. Look here. No, we're not. You need to leave. You need to leave. You need to leave. No,
I'm working on.
No, it's not yours. He's towing it. His car.
He's towing it to my house.
No, he's not.
Yes, he is.
No, he's not. No, he's not. Hey, sir. Hey, it's going to impound. It's going to impound. I call Terry. Hey, sir. It's going to impound. It's going to y'all. He okay. No. It's going. Yep. It's going. Yep. He's something else, Eddie. He's going. It's not going to. I told him it's going to the 2 yard.
You didn't see the busted meth pipe laying out there?
He said it was where? What they do?
But laying out there in the wood line, busted.
Okay, but we can't. I mean, that's.
I know you can't charge with that.
Right, but. Huh?
No, they took the keys to it.
Hey, let them keep charging for that. You can charge for all that. Hey.
I can put a lock on it.
Huh?
Yeah.
So I won't have to drag it.
Do whatever you got to do. Charge him. Guess what? I mean, it's all because he won't
drag it up there. That's fine.
Okay.
Drag it.
Okay. I mean, whatever you got to do, and charge him for it. It's not their car. They can't come get it. This lady's got to come get it. When I give you the name, she got to come get it. She's got an orange.
They got in their tag or nothing.
Y'all will probably end up with it. You know what I'm talking about? So that's what he's worried about. That's why he's mad. He wants to this place. And I told him no. Come on.
I understand. Like I told him, y'all got control of this situation.
Yeah. So it's your car. It's you towing it.
Should have pulled him over and gave him tickets for riding in the bed.
I mean, they like, bro. They cussing me and all that stuff. I mean,
I swear, Lonnie, shit you get me wrapped up in.
Turn you off. Cameras included. Cameras off.
Okay, so obviously I've shown my cards in my opening, but I didn't arrive at a position before I did a full analysis on this video. So to start out, I'm going to make the very best argument I can come up with in defense of Sergeant Baker, and then I'll do the same for the opposing viewpoint. If I'm arguing in defense of Sergeant Baker, this is what I'm hanging my hat on. He arrived to find what appeared to be a disabled vehicle partially obstructing a public roadway. The vehicle's hood was up, its tires extended partially onto the roadway in the opposing lane of traffic. Under the community caretaking doctrine, law enforcement officers may approach and secure roadway hazards without suspicion of criminal activity. The community caretaking function is not investigatory in nature. The purpose is public safety. Caretaking authority continues until the hazard is resolved, until the vehicle is towed and the roadway is safe. There is no constitutional defect, in my opinion, in the deputy's presence, approach, or observation of what was visible from a lawful vantage point. Now, shortly after getting out of his patrol vehicle, Sergeant Baker made contact with multiple individuals on the passenger side of the vehicle. While lawfully present, Sergeant Baker observed an open container of alcohol in the center console. Florida law prohibits possession of an open container in a vehicle being operated on a public roadway. The vehicle was partially obstructing traffic on a public roadway. It did not arrive there by accident or magic. A reasonable police officer could infer recent operation. And because the can was in plain view, and because the vehicle was positioned on a public road in a manner suggesting recent operation, the deputy had probable cause, or at minimum, arguable probable cause to believe the statute was being violated. Under the plain view doctrine, he was lawfully present, the item was in plain view, and its incriminating nature was apparent based on the surrounding circumstances. Therefore, the seizure of the can was likely lawful. Now let's talk about the detention. The presence of an open alcoholic beverage container in a vehicle partially obstructing traffic does give rise to reasonable suspicion of DUI. DUI requires operation. The vehicle had been operated recently enough to be positioned in the roadway. Multiple individuals were obviously present. It was reasonable to briefly detain individuals to determine who had been operating the vehicle, whether impairment was present, whether citations or charges were warranted. Under Terry v. Ohio, officers may briefly detain individuals based on reasonable suspicion that criminal activity may be afoot, and this particular detention was temporary and investigative in nature. Now, as it relates to demanding identification, during a lawful investigative detention, an officer may request identification. If DUI or traffic violations are under investigation, identifying the operator is essential to issuing citations and completing reports. The deputy requested identification in furtherance of that investigation. Failure to comply during a lawful detention may constitute obstruction under Florida law, specifically resisting without violence. Officers are permitted to maintain control of investigative scenes. Alcohol-related investigations carry inherent safety risks. When the individual became argumentative and resistant to lawful commands, the deputy escalated tone and asserted authority to maintain control. Threatening arrest for obstructing during a lawful detention is constitutionally permissible. Under the totality of the circumstances, the defense of Sergeant Baker would contend that his actions were reasonable. Now, that's the very best I could do in arguing for the defense of Sergeant Baker. Let's start with some concessions. I wouldn't dispute that the deputy's presence was lawful. I would agree that community caretaking does allow for the parallel concern about the vehicle being in the roadway until it's safely removed. Caretaking and investigation can coexist, right? This is not the issue. Whether a predicate existed for a lawful detention is another matter. And because the first enforcement action undertaken by Sergeant Baker was reaching into the vehicle, we first need to start with the seizure of the beer can. Now, you'll recall that the plain view doctrine has three essential elements. Number one, the officer has to be in a place where he has a lawful vantage point. And this is really undisputed here. Sergeant Baker was lawfully present and observed the can in plain view from a lawful vantage point on the passenger side of the vehicle. Number two, the illegal nature of it must be immediately apparent, and this is where the case for Sergeant Baker's defense begins to crumble. And number three, the officer must have a lawful right to access the item, and this hinges on the illegal nature. Unless the illegal nature is apparent, there's no lawful right to access in the absence of consent. The problem with the illegal nature is that Florida's open container statute does not regulate objects like a beer can. It regulates a condition, meaning that possession of an open container is unlawful only when all statutory elements exist contemporaneously, or in other words, at the same time. So in order to determine that, we need to look at the Florida statute 316.1936, possession of open containers of alcoholic beverages in vehicles. And here's the relevant structure. A person operating a motor vehicle may not have in his or her possession any open container of an alcoholic beverage in the passenger area of the vehicle. A passenger may not possess an open container of an alcoholic beverage within the passenger area of a motor vehicle while the vehicle is being operated on a public roadway. So the essential elements are the container is possessed in a vehicle being operated on a public roadway. So operation is not a suggestion. It is an essential element of that offense. And in the absence of that element being probable cause cannot be established. Therefore, the reach into the vehicle, while seemingly reasonable, cannot be constitutionally justified, because at the moment the deputy reached into the vehicle, the engine was off, the hood was open, no driving was observed, no operator was identified, and there was no contemporaneous operation established in order to satisfy PC for an open container violation. Sergeant Baker relies improperly on inferences that are unreasonable in light of the facts at issue. He argues that the vehicle had to have been driven there, but the statute requires operation at the time of possession. There are no facts to show when the vehicle became disabled, how it got there, whether it was being operated or towed at the time it became disabled. And furthermore, there are no facts that establish at what point the beer can was placed there, or who would be responsible for its placement. If operation is not established, the condition that makes possession of the beer can unlawful is not there. Plain view requires that the incriminating nature of the item be immediately apparent. And if illegality depends on a fact that has not been established, in this case operation, then the incriminating nature is conditional, and that condition is never met because we're not operating. That is the constitutional defect in the seizure of the beer can. Now, what about the detention? We need to look at whether or not the person who claimed ownership of the vehicle, the gentleman on the driver's side of the vehicle, was seized under the Fourth Amendment, and if so, whether that seizure was lawful. As you'll recall, a seizure under the Fourth Amendment occurs either when a person submits to the exercise of authority of a police officer seeking to detain the person, or the officer applies physical force to effect the detention. Throughout this encounter, on multiple occasions, Sergeant Baker uses verbal commands to control the movement of the person on the driver's side of the vehicle, and that person submits to Sergeant Baker. Therefore, he is seized for the purposes of the Fourth Amendment. Hey guys, I didn't even notice until I was editing this video in post-production, but he actually does make physical contact with him. So to the extent there was any dispute as to whether or not he was seized, the application of physical force proves that he was. But he also conducts an illegal pat down here that you'll see in the next clip that I've slowed down. So the question then becomes whether that seizure was lawful. And the first thing we need to look at in order to determine that is what is required for a lawful seizure. So we know that pursuant to Terry v. Ohio, an officer conducting an investigatory detention needs either reasonable articulable suspicion that criminal activity may be afoot, or probable cause that a traffic violation has occurred. Significantly, Florida's legislature has intentionally bifurcated most traffic offenses from criminal offenses, and all of the potential offenses other than DUI here are civil. And so even though the open container can't be proven, as I explained earlier, even if it could, it is considered a civil infraction. So Sergeant Baker's statement to Mr. Goulet that he could take this other gentleman's ass to jail over the beer can is not just inaccurate because he couldn't establish PC for the open container violation to begin with. It's inaccurate because even if he could prove it, it's not a crime. Similarly, any potentially citable offense for the registration violation also has the essential element of operation, and thus nothing can be proven here either. But if they could, they are all civil infractions. DUI is the only potential crime here, but DUI, like the other things, requires operation. Here, at the moment of detention, we have no driving observed, we have no operator identified, we have no impairment articulated, we have no omission, and we have multiple individuals present. The deputy may have had a basis to investigate who drove, but because he chose not to do that, he did not have individualized suspicion tying this specific person to operation of the vehicle. The Fourth Amendment does not permit detention based on the possibility that someone could commit an offense or did commit an offense. Suspicion must be particularized, and it's very clear that that step was downright ignored, and Sergeant Baker showed no real interest in investigating a DUI. As it relates to identification, compelled identification during a detention must rest on the lawfulness of the investigative authority tied to a criminal predicate or probable cause having been established to issue a citation. In the absence of operation as it relates to all of these offenses that were within the realm of possibility, there was no lawful reason to demand ID from any person on this scene. I know most of us would probably look at this and say this guy was falsely arrested, but the facts are that he did not submit when threatened with arrest to give his information. He was not handcuffed, and other than being given verbal commands to which he did comply, he was not arrested. So we don't have an unlawful arrest, but in my opinion, we do have an unlawful seizure. So as far as constitutional violations, my opinion is that Sergeant Baker violated the Fourth Amendment by entering the vehicle to grab the beer can, thus committing an unlawful search. I believe he also unlawfully detained the gentleman on the driver's side in violation of his Fourth Amendment right to be free from unreasonable searches and seizures. Now, as far as what I think a court would actually do with this case if the man were to sue, I believe that the court would probably grant qualified immunity on the reach inside the vehicle. And I say that not because it's not a violation, but I say that because the open container law is so mechanical. A reasonable police officer might believe that arguable probable cause existed to seize the can. And while I don't believe that seizure was lawful, I also don't see a court stripping qualified immunity on that claim itself, especially given the severity of the other claims we have here. And more importantly, I believe that the officer's behavior after seizing the can actually hampered any argument that would be reasonable to support a detention thereafter. Because we have to remember that reasonable suspicion is based on what an objectively reasonable officer would do given the information subjectively known to the officer at the time of the seizure. So what a reasonable police officer would do if he knew what Sergeant Baker knew in the moment. And as crazy as it is, I believe the merits of that entire claim hinges on the condition of the beer can itself. When Sergeant Baker grabbed it, if the beer can was cold, it could arguably indicate that someone was consuming it in a vehicle that had been recently operated. If it was not cold, that argument would fail. So not only did Sergeant Baker likely violate the Fourth Amendment by seizing it, it also probably provided him information that he would be held responsible for knowing prior to conducting an investigatory detention on this gentleman. Now, we have no idea what the condition of the can was because he didn't say anything about it, but that's telling in and of itself because we observe him take the can, set it on top of the vehicle, and then slide his hand down towards the bottom of the can, indicating that he was at least trying to figure out whether the can was cold. And the fact that he made no comment about the can afterward, I think leads to a reasonable inference that the can was not cold. I say that because the fact that Sergeant Baker displayed such a hot-headed nature throughout this encounter, needlessly escalated this, threatened jail on multiple occasions, took no action after the men said they would submit to a breath test, and declared that the beer wasn't theirs, I believe combines and works to show that the can was not cold, because I believe Sergeant Baker proved during this encounter that he was the exact kind of guy who was willing to leverage anything he possibly could, lawful or not, to assert dominance. And if the can was cold, I believe that he would have made a bigger deal of that. And for that reason, I believe that the court would find a violation of the Fourth Amendment for the detention of the man on the driver's side of the vehicle. But assuming that the court were to disagree with me about that and say that reasonable articulable suspicion existed at the outset of the detention for DUI, I believe even if that were the case, and the court were to assume that Sergeant Baker had reasonable suspicion to briefly detain the individuals to determine whether a DUI had occurred, the detention must still remain reasonably related in scope to that suspicion. And under Terry and Rodriguez, an officer may not expand or prolong a detention beyond the mission that initially justified it. Here, Sergeant Baker did not conduct any sort of DUI investigation. He didn't ask in any serious way who possessed the keys, whether anyone had been drinking, or whether the vehicle had been recently operated. He did not observe or articulate any signs of impairment on anyone. He performed no field sobriety tests. Instead, he escalated the encounter, threatened arrest, demanded identification, and focused on towing the vehicle. It seemed like that was his only motivation. So if the detention was justified at all, it was justified only for the limited purpose of investigating a possible DUI. And once the deputy failed to pursue that mission and instead shifted to authority enforcement and property seizure, the continued detention exceeded constitutional bounds. Courts have repeatedly held that a detention that is lawful at the outset can become unlawful when it is extended in time and scope beyond constitutional boundaries. And for that reason, I believe the court would not grant qualified immunity once it exceeded constitutional parameters. Additionally, I believe a strong argument could be made for a First Amendment retaliation claim in light of the repeated threats of arrest Sergeant Baker made, going so far as to threaten to find a reason to take the man to jail, despite the fact that the only potential criminal offense within the scope of the interaction was never seriously investigated. The fact that Sergeant Baker only threatened arrest to the person pushing back, he only controlled the movements of the person pushing back, he repeatedly let everybody else do whatever they wanted to do, and he expressly stated that he would arrest the man because of his speech, created the nexus for all of the elements of a First Amendment retaliation claim. The right to free speech was the one at issue. It's fundamental. It is historically protected speech to push back and criticize police officers. The detention and threats of arrest would chill a person of ordinary firmness from exercising their right, and Sergeant Baker expressly stated that he would find a reason to arrest him, not because of a crime, but because of the fact that he was running his mouth. And that created a causal relationship between the exercise of protected speech and the enforcement action, which would likely satisfy a First Amendment retaliation claim. And because the First Amendment right to criticize police officers in the course of their duty has been well established for decades, I don't believe there's any defensible position for offering qualified immunity for First Amendment retaliation under these circumstances. In closing, Sergeant Baker is a perfect example of why I don't attach any sort of credibility to the notion that because someone has been a police officer for X number of years, that means they know what they're doing. If anything, this interaction stands for the proposition that you can be incompetent for decades and still be a cop. The fact that Sergeant Baker spent decades as a Florida trooper and has apparently been a police officer active in some capacity since 1985 and is still so hot-headed and incapable of controlling his emotions is a true stain to the profession. Based on this interaction, my opinion is that he is one of the least knowledgeable and inarticulate police officers I've ever observed. He seemingly either does not care or has no understanding of constitutional principles or Florida law, and he shows no deference to well-established case law. In addition to all of the things I mentioned before, he also basically gave away someone else's property to a tow yard and told them that they would probably end up with it because the guy wouldn't be able to pay for it, and that was probably what he was actually worried about. So he took property that belonged to somebody else for no good reason, and he made its removal so expensive that there would be no way for them to get it back. And I looked at the comments on the original video, and the original poster did say that they ended up losing the vehicle. So it can be reasonably stated that based on this interaction, Sergeant Lonnie Baker's primary interest was just in separating this person from their property and threatening anyone who might seek to challenge his authority to do that with arrest. I don't argue that he didn't have the authority to tow it because of the fact that the tires were barely in the middle of the road, and I think it would be disingenuous to say that that wouldn't create some sort of dangerous condition on the roadway, but they offered to remove it themselves. He even intervened and kept the guy from having it towed to his own house, and the guy was probably willing to pay to have it towed because he wouldn't have had the guy tow it to his house if he wasn't going to pay him. So this guy's without a car for really no good reason, just because he pissed off a police officer who in the moment felt like he was going to do whatever he wanted to do consequences be damned. Anyway, I just saw this as a great opportunity. It seemed like a gold mine full of ways to analyze this case and talk about how sequence matters. What he knew before he reached in the car mattered, and what he learned from reaching in the car mattered as it relates to what he could lawfully do next. And all those things make a difference chronologically in whether a situation was lawful or unlawful, depending on when and time they happened and what significance they had. So it was a good opportunity to talk about all that stuff. I hope you guys enjoyed it. I'd like to invite you to check us out on all the socials. I'll put up a QR code here for you to scan with your phone. That'll take you to the Linktree site where you can check us out on YouTube, Facebook, TikTok, and Substack. You can join on a paid tier of Substack if you want to, but that's only for people who want to support the channel monetarily. I don't put anything on these platforms that people have to pay for. If you don't want to follow us to another platform, but you'd like to support monetarily, I'll leave my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel. Leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.